welcome to Hanne's online workshop about returning to the workplace after the COVID-19 lockdown. My name is James Collier. I'm an employment solicitor at Hanne & Co Solicitors. I specialised in employment law for the past 10 years, and I deal with employers and employees' employment law issues. The agenda for today's talk will first identify what the UK government guidance on the COVID-19 roadmap out of lockdown is. We're halfway through that now, coming up to the stage 3 in that process. Then I'll talk about managing COVID risk in the workplace, and we'll deal there with the UK government guidance on different workplaces, and also the statutory, common law and contractual duties of employers in respect of health and safety. And we'll look at briefly the claims that employees may bring in relation to health and safety in the workplace. And then we'll take a particular look at the considerations for disabled and pregnant employees. We'll look at some specific questions around, can I require a worker or employee to have a COVID-19 test or vaccination before attending work? I'll deal with a few scenarios that have been sent in by attendees, and specifically they focus around one main point really. And then we'll deal with some questions and answers. So the UK government Spring 2021 roadmap published on the 22nd of February this year. We've been through the first 2 steps where some non-essential businesses and outside businesses were allowed to open. And we're heading towards step 3, 17th of May, where most other businesses are allowed to open except very high risk businesses, which are then allowed to open on the 21st of June this year, large indoor performances and nightclubs. And on the 21st of June, most other legal restrictions on social contact are removed. So just on the government roadmap for the next slide, working from home continues to be recommended until at least step 4 on the 21st of June. The UK workplace social distancing guidance and advice from the government, which we will look at briefly in a minute, but there is potential for that to be reviewed. So look out for advice on intermittent distancing, increased use of masks and screens, and the continuation of hygiene in the workplace advice. On the 1st of April 2021, under the Spring roadmap, those on the clinically extremely vulnerable list were advised that they were no longer required to shield and should return to the workplace if they cannot work from home, and they no longer would be eligible for statutory sick pay payments if they remained off work due to shielding. And workplace COVID-19 testing is recommended by the UK government in their roadmap, and 2 tests per week are recommended for each worker, and 3 tests until the end of June can be accessed for employers with under 50 employees. Can use the local authority and NHS asymptomatic testing services for their staff. So where are we in the workplace? And the TUC has done a recent survey which suggested that not 100% of employers were involving their health and safety representatives in their risk assessments. Only 27% said they'd been involved in those. Only 31% believed that appropriate social distancing rules and barriers were being implemented by their employer in the workplace. Only 29% said their employers were implementing appropriate distances between employees and customers. And 65% of employers had dealt with an increase in the response in the referrals for mental health stresses since the pandemic began. So overall, not a great picture from the TUC assessment of workplaces going into the period where we're coming out of this lockdown. So what is the UK government's advice on working safely during coronavirus? And they've produced, the UK government produced 14 different guidances on dealing with different workplace types. So it's best if you visit the gov.uk guidance website, link at the bottom there, and find the guidance that is appropriate for your types of workplace. For example, offices, transport, close personal contact services such as massage, hairdressers. There are factory environments guidance, but throughout the 14 different guidances, there are 5 common themes, which we'll deal with briefly now. So the 5 main themes applicable to most businesses and workplaces from the UK guidance on safe working during coronavirus is for employers to carry out a COVID-19 risk assessment. And employers would be assisted here by the Health and Safety Executive, the HSE website, where there are template COVID-19 risk assessments available for employers to download and tailor to their needs. And that risk assessment might be a global one for the business or a site-specific one if there are different circumstances at different sites of the employer, or for different activities, different activity streams of the employer, so office-based work, transportation, or factory-based work. Their employers should develop cleaning, hand washing, and hygiene procedures, so providing the materials for that and the processes and training and support to ensure that staff comply with those procedures. Help for employees to work at home, and that's what we've been doing over the last period, but working from home still is the most effective way to control coronavirus transmission, so that there may be consideration placed to more widely available working from home for workers and employees. Maintaining the 2-metre social distancing rule in the workplace where possible, so that's placing signs in the office so that one-way systems are used. That's making sure that people's desks are facing in the right way, so facing away from each other preferably, rather than facing towards each other, which has been the traditional format. And where 2-metre social distancing isn't possible, employers must take active steps to manage transmission risk in the workplace. So masks, facial screens, hard screens on desks, rota working so that there are fewer people in the workplace and therefore social distancing is more easily introduced. But also here I've put, think about ventilation for indoor environments. And I know that it's important now to check ventilation systems so that they are serviced correctly and set to the right settings to reduce coronavirus transmission risk rather than enhance it. So they're the 5 main themes from the UK government guidance. Now, a look now at what are the employer's statutory and common law duties in relation to health and safety in the workplace. So Section 2 of the Health and Safety at Work Act provides that as far as reasonably practicable, employers must take reasonable steps to ensure the health, safety and welfare at work of all of their employees. And a failure or disregard of this requirement can amount to or can trigger criminal charges for the employer, as well as the civil claims brought by the employee that we'll deal with later. An employer's common law duties in relation to their workers and employees are that they will provide their employees with a safe place of work, safe tools and equipment, and a safe system of working. And you can see that those common law duties would bring into those issues, a safe place of work, safe tools and equipment, and safe system, considerations of minimising the risk of coronavirus transmission in the workplace. So common law duties to take steps, and also implied into all contracts of employment, there are implied by law terms that require an employer to take reasonable care of the health and safety of employees and provide a reasonably suitable working environment for the performance of the employee's contractual duties. And so those are fundamental terms of the contract of employment. And if breached by the employer, that would or could have the effect of bringing the contract to an end. That what I'm saying there is repudiating the contract and that enables the employee to resign and claim they have been constructively dismissed. So a breach of the implied terms of around health and safety by the employer may give rise to claims for constructive unfair dismissal, constructive dismissal by the employee. So a little deeper delve now into the health and safety obligations of an employer in the workplace. So the Management of Health and Safety at Work Regulations, 1999, provide a bit more detail of what the employer is obligated to do in the workplace regarding health and safety. And the first one there, Regulation 3, is carry out a risk assessment of the workplace. And that's a more, as I say, global or site-based or activity-based risk assessment, not an individual employee risk assessment, a broader assessment of the health and safety risks posed to employees by that workplace or that particular site or that activity. And then the employer must show that they have effective planning, organisation, control and monitoring and review of any preventative and protective measures identified by the risk assessment. Now, obviously, this can include the risks of coronavirus transmission in the workplace. And so the risk assessment should include that too. And appropriate monitoring of health and safety risks identified by the assessment. So planning and organising and control of to reduce the risks, and then monitoring of the risks, appointment of a health and safety representative, and finally, establishment and use of procedures for situations where there is a serious and imminent danger to persons at the workplace. So that obviously could encapsulate, include coronavirus transmission risk in the workplace. So a policy in place for circumstances where there is an identified risk of coronavirus transmission in the workplace, and a procedure for staff to follow that would allow them to mitigate those risks with immediate effect. And the regulations provide that employees must be made aware of the risk assessment and the procedure to follow for in the event of serious or imminent danger. And the regulations further provide that if there's over 5 employees employed by the employer, all of those details I've spoken about there must be provided to the employee in writing. So what claims can employees bring against their employers if they consider there have been health and safety failures? And specifically around coronavirus transmission in the workplace, the following claims would include such coronavirus transmission health and safety concerns being raised in the workplace. So an employee may have the right to make a claim for detrimental treatment under Section 44 of the Employment Rights Act if they consider that they've been treated detrimentally by their employer for having raised health and safety concerns, or for having withdrawn from the workplace if there is serious and imminent danger, if they reasonably consider there is serious and imminent danger, or if they've been treated detrimentally by their employer for any of their health and safety representative functions. Such detrimental treatment often is often brought alongside an automatic unfair dismissal claim under Section 100 of the Employment Rights Act, and that's where the employee is really saying, either I've been dismissed by my employer expressly because of my raising my health and safety concerns, or I've resigned further to a series of detrimental treatment by my employer which repudiated my contract. So my resignation actually is a constructive automatic unfair dismissal. And the thing to bear in mind about that claim is an automatic unfair dismissal claim is not limited by the statutory cap on compensation. And so potentially there is an unlimited award of compensation there should the employee succeed in that claim. So those two claims are often brought together, and ones to watch out for in particular when the employees are raising health and safety concerns in the workplace. But there are also potential claims for constructive or express ordinary unfair dismissal, for breach of the implied terms of the employment contract. We spoke about that briefly before. And also if the employer dismisses expressly, there is also an express ordinary unfair dismissal claim there potential as well. And layered on top of all of those claims, there's possible disability and potentially other protected characteristics such as age and religion, discrimination claims, if an employer is treating the employee differently, for example, because they haven't agreed to take the vaccine. Now, there's also a potential risk of a health and safety executive investigation or local authority if they're authorised to do that type of investigation, for example, food safety. And the employer can be investigated regarding the employee's complaint. So moving on now to some specific questions around what can employers lawfully do around conducting temperature checks or requiring a COVID-19 test or a vaccination. So can employers lawfully conduct temperature checks on employees, workers or visitors? Now, dealing specifically with employees and workers here, yes, if there is a legitimate reason for doing so, usually provided for within the contract of employment of the employee or worker and the relevant health and safety policy. I think with a visitor, it would be like more along the lines of, well, if you would like us to grant you access to our building, then there is the requirement to have a temperature check for that. But for the employee and the worker, usually the right to do such, or the authority to do such testing is included in the contract of employment or health and safety policy. But employers must always bear in mind that any kind of health testing or the administration of a treatment, i.e. a vaccine, requires the informed consent of the employee. And if informed consent is not provided, the employer could be vulnerable to constructive unfair dismissal claims and even potentially to a criminal charge of assault and battery. And it's also really important to remember that this type of data is enhanced or sensitive data under the Data Protection Act and the General Data Protection Regulations, and therefore must be dealt with care and in compliance with those requirements by the employer. So informed consent and treated with confidentiality. So can an employer require an employee to take a COVID-19 test at work or before returning to work? So we mentioned earlier that the current UK government recommendations are for employees to take two rapid flow tests per week, and those can be accessed freely from local authority or NHS testing services. However, again, it's important to remember that any test has to come with the informed consent of the person being tested, and therefore it may be important to educate, train, and maybe incentivize the workforce. There may be a sense of unnecessary invasion of privacy. There may be other barriers to consent to testing and possibly vaccination, which we'll deal with next. And therefore, consultation with the workforce is going to be key around these new requirements, key around underlining the effectiveness and safety of both the testing for coronavirus and also the vaccination, but also the wider benefits, both individually to the individual. You understand your COVID status when you test, and the wider community is kept safer if we're able to identify those within the community that are positive for coronavirus, and that's the reason why we're doing it. So incentivizing the testing from both the individual perspective and the community group or workforce perspective. And then the requirement for a COVID test could be introduced as part of policy changes to reflect new working conditions in the return to work environment, or included as a contractual requirement in future contracts of employment. And it's always advisable to consult and engage with employees and secure their written agreement before inserting such a requirement into existing contracts of employment or updating existing internal policies to require the COVID-19 test either at work or before returning to work. So really strong, open dialogue and consultation with your employees and wider workforce around the reasons for testing, the efficacy of testing, the safety of testing, and the rationale overall to keep the workforce community safe. Okay, can an employer require staff to take a COVID-19 vaccination? So the answer to this is no, an employer cannot mandate that an individual takes a COVID-19 vaccination. Again, it's a treatment or a test and it requires the full and informed consent of the individual. So COVID-19 vaccination is voluntary and requires the informed consent of the individual. The employer could mandate the requirement to have a COVID-19 vaccination as a term of a new contract of employment, one which is agreed after the kind of wider vaccination process has been rolled out. However, ACAS does advise against this in its guidance on COVID-19 vaccination, and probably because such a policy of mandatory vaccination probably risks challenge on the grounds of indirect discrimination. That's where a policy or procedure criteria of the employer places in individuals who share a particular protected characteristic, such as age, disability, pregnancy, sex, race, or religion. They're the ones I thought might be particularly relevant to a mandatory COVID-19 vaccination policy. Those people who share that grouping at a particular disadvantage, and that may not be capable of objective justification by the employer. So there are risks there from certain groups, from a mandatory vaccination policy, that, for example, somebody who has not yet been offered the vaccine because of their age could not comply with that requirement and therefore are placed at a particular disadvantage by that policy, which might not be justified as, you know, a younger person may be able to get the vaccination at a later date and have their duties adjusted until that date, for example. That may be a more proportionate way of achieving the legitimate aim of protecting the workforce by requiring vaccinations of all employees. Okay, moving on. Requiring current employees to be vaccinated may trigger tribunal claims for repudiatory breach of contract and indirect discrimination, depending on how the process is applied and whether a particular disadvantage is caused to that grouping. Now, vaccination continued. Things to consider. Vaccination isn't suitable for everyone. Some pregnant women or those already ill with COVID-19 can't take the vaccine. I know pregnant women are, the recommendations around offering them the vaccine are now changing, so that may change. A mandatory vaccination policy may not be justifiable. It may be better to target roles with a demonstrable risk where social distancing is difficult. And the employer may facilitate voluntary vaccination of the workforce by collective consultation with recognised trade union or employee health and safety representatives, or if it's a small employer, then with individual employees, and a proactive communication strategy around the vaccine, its safety and efficacy, and its wider benefits in controlling coronavirus transmission. I think there's good evidence around that now. It doesn't do that, reduce transmission completely, but it certainly reduces it by a significant degree. And then it also reduces by a very significant degree the serious illness and death from coronavirus infection. So clear communication around those benefits and potentially incentivizing vaccination. So time off for the vaccination or time off if a worker suffers side effects from the vaccination. Dealing now with COVID-19 and pregnant employees. So I wanted to sort of demonstrate here that coronavirus and the risk of coronavirus transmission in the workplace to pregnant employees just kind of slots in with the general guidance that's given for employers when managing employees who are pregnant in the workplace. So an employer has legal duties towards expectant mothers in the workplace to assess workplace risks posed to the mother and baby by doing a risk assessment, by altering the working conditions or hours of the employee or worker to avoid any significant risk. If it's not reasonable to do this or wouldn't avoid the risk, to offer the employee suitable alternative work on terms that are not substantially less favourable. And where that suitable alternative work isn't available or the worker reasonably refuses that offer, the employer may have a legal duty to suspend the pregnant employee on full pay if that is the case and no alternative work can be found and there is an unavoidable significant risk. And requiring pregnant employees to continue to work in frontline roles where the risks cannot be avoided may amount to indirect discrimination. And there are further pieces of advice in the UK government advice for employers accessible on the link below. Now, COVID-19 and disabled employees has the potential to be a really big issue with long COVID. But just to tease apart some of these definitions at the beginning, so disability status and appearing on the COVID-19 clinically extremely vulnerable list are different. So to have disability status, you must satisfy, or worker, an employee, must satisfy Section 6 of the Equality Act criteria for disability status or have a deemed disability, and that's one of those three diagnoses, cancer, MS or HIV. Somebody who is on the clinically extremely vulnerable group has been placed there by the UK government on the advice of medics, and those people are specifically, when they have specific conditions that place them at additional risk of COVID infection, and they are people who have received a transplant, for example, sorry, excuse me, respiratory or some other cancer diseases or immunosuppression conditions. But what I wanted to point out is it's not automatically the case that if you appear on a clinically extremely vulnerable group, that you automatically satisfy the definition of disability in Section 6 of the Equality Act, or you have a deemed disability. You need to work through the statutory definition of disability in each case to determine whether that individual employee is disabled. And it may well be that if they appear on the clinically extremely vulnerable list, that condition causes them to satisfy the definition of disability. And I wanted to sort of tease out another issue here, that symptoms related to long COVID, so that's ongoing symptoms of COVID infection after the initial acute infection has passed, may amount to a disability if they cause long-term substantial adverse effects on the employee's ability to carry out their usual daily activities, and that is Section 6 of the Equality Act. So long COVID symptoms may well cause an individual to be disabled and the employer to be placed at additional legal duties to manage that person's employment and not discriminate against them because of their disability. So those three sort of definitions and things to think about for an employer, I think, are important from a COVID-19 perspective. Now, COVID-19 disabled employees, if an individual is disabled for any of their conditions, or because they're on a clinically extremely vulnerable list, or because they've got long COVID, an employer will be placed at a positive legal duty to take reasonable steps to make adjustments to its policies, criterion or practices, or to its physical features of the workplace, or to provide an auxiliary aid if the disabled employee is substantially disadvantaged by those features or by those policies. So a real positive legal duty there to take reasonable steps to adjust certain features or policies if the disabled person is substantially disadvantaged by them. Now, there's a duty on an employer not to treat the disabled employee unfavourably because of something that arises in consequence of their disability. That's a claim for discrimination arising from disability. Not to treat the disabled person less favourably because of their disability, direct discrimination, and by acts or omissions that have the effect of violating the disabled worker's dignity or creating an intimidating, hostile, degrading environment, that's by acts or omissions related to the disability, and that such conduct may amount to disability-related harassment. And I can see those arguments being raised by people with a disability in relation to the management of their work and the risks of COVID, for example. And not to apply policies and procedures that cause disabled employees particular disadvantages that can't be objectively justified. That's indirect discrimination. So a range of duties there, that all of which could be relevant and engaged in relation to disabled employees and the employer's management of the disabled employees' return to work after the lockdown, and in relation to ongoing risks of COVID infection in the workplace. So things to think about for an employer when managing a disabled employee in the workplace are: keep all the evidence of the related, of the individual risk assessments and health information, including GP and occupational health reports. Ensure there is a written record of all agreed adjustments in the workplace, and the TUC have developed what's called a disability passport, where an employer and an employee record their meetings that they have around the disability, record the disadvantages that are caused by the policies or the physical features, and then they record the agreed adjustments. It's very helpful when managers move on and the disabled employee is left then with a new manager, and they can just give them that disability passport that has the record of their agreements in it. Retain all documentary evidence of the employer showing it has given consideration to the employee's stated needs, and detailing taking reasonable steps to provide the adjustments. And I always say, if an adjustment is refused, keep that evidence as well. Show that you've assessed the disadvantages it's said to cause, what policy causes the disadvantage, what physical feature is the disadvantage, and then show that you've done an assessment of the adjustment that's been requested by the employee, and reached a conclusion that for your business in particular, for a reasonable reason, the adjustment is not reasonable in those circumstances. It may be that the adjustment would affect your wider ability to carry out your activities. It may be that the adjustment would have a health and safety impact on the wider workforce. Or it may be that the adjustment would not effectively alleviate the substantial disadvantage faced by the disabled employee, and for that reason it's not reasonable in the circumstances. But it's important to keep all of that evidence, because that will be great evidence to dispute or defend a claim for reasonable adjustments made by the employee. Okay, and then in the Equality Act there are potential defences for employers that they took all reasonable steps to prevent that discrimination from occurring. And if an employer can show that they've provided training to their wider workforce, but particularly the managers that manage disabled employees, if an employer can show that they've provided those managers with training on managing disabled employees, providing reasonable adjustments, and ensuring equal opportunities are delivered in the workplace, then an employer may be placed in a better position to avail itself of that statutory defence, the reasonable steps defence, and provide the tribunal with legitimate evidence of the employer having taken steps to try and reduce any chance of discrimination in the workplace. Now, that was a quick skip through my slides, and I hope they were helpful, and I hope they sort of drew to the employer's attention the considerations that should be going through the employer's mind when thinking about returning people to the workplace. It's going to be a scary time for employees and workers, and they're going to want leadership and management and to understand what steps have been taken by management to mitigate the risks of coronavirus transmission in the workplace. And those sort of steps would be, I would argue, the legal responsibility of the employer to take under the Health and Safety at Work Act and the Management of Health and Safety at Work regulations that we spoke about. And a failure to take those reasonable steps may trigger claims from the employee that have significant compensation risks in the tribunal, as we spoke about. Now, the scenarios that were sent in by people, thank you very much for those. We had 4, and 3 were very similar. So I'm going to outline that scenario now, and I'm hoping it sort of captures 3 of those scenarios raised. The scenario was, how do we manage an employee who is reluctant to return to work, i.e. either an office-based role or a role that's based outside of the home, really, so at a workplace venue or site? How do we encourage or manage an employee's return to work who doesn't want to return to work? Now, I think there's 2 ways of answering that question. One is that the employee does not have a long-term condition that amounts to a disability and therefore is not disabled. And for that employee, for the non-disabled employee, I would be, because we've already identified that if they're not disabled, but yet they still appear on the clinically extremely vulnerable group, government advice is that they should now return to work. Even if they can't work from home, they should return to the workplace. So that if an employer can show to that employee that they have done their COVID risk assessment and shown it to the employee, they have taken the steps to mitigate the risks, they've socially distanced the office environment, or they've split up their staff teams so that only half are in at any one time, so that 2-meter distancing can be achieved. They've set up their hygiene processes, and they've retrained their staff on all of these new procedures, and they're carrying out COVID-19 testing of staff who have all bought into the idea and are regularly testing, and an employer has a record of 80% or 90% of its staff who are coronavirus negative, tested twice weekly. Then I think all of that evidence shown to the employee should reasonably satisfy that employee that the workplace has been made as safe as reasonably possible. The employer has complied with all of their legal obligations, and it is now giving a reasonable management order under the contract as it is authorised to the employee to return to work. And if the employee still refuses after that consultation and negotiation process has taken place, and the employer has all of that documentary evidence in its possession, then I would suggest that a formal disciplinary procedure could be applied at that stage. Now, in the hope that the employee would re-engage and come back to work at some point. But if dismissal did result, then it would be up to the tribunal to determine whether that dismissal was further to a refusal of a reasonable management order, and whether the decision to dismiss fell within the reasonable range of reasonable responses of a reasonable employer. And I would hope that that evidence would persuade an employment tribunal that the employer had acted reasonably in those circumstances. If, however, the employee is disabled, then as we spoke about, the employer has additional duties to reasonably adjust that policy of requiring all staff to come into work. And it may be that it is a reasonable adjustment to allow the employee to work from home, for example, or to come in only 1 or 2 days per week, or to work a rota of what is best for their condition and alleviates the disadvantages faced, but also what enables the employer to efficiently carry out their business. So there's a meeting there, and what is reasonable in the circumstances for one employee may be different for a different employee, to take account of alleviating the substantial disadvantages that the individual faces because of their disability in relation to the policies and procedures of the employer. So two different answers there for two different profiles of employee, but I hope that's been a bit helpful. Now, I'm sure you've had enough of listening to my voice, but thank you very much for coming today and listening to the Hanne & Co online workshop for returning to work after the COVID-19 lockdown. Please do think of us for any of your employment law needs. We have a very experienced employment law department, and we can review your contracts. We can consider your contracts of employment and, as we say, advise you on either varying them or drafting new ones for your future employees to incorporate these terms that will enable the employer to exercise some additional authority around requiring staff to take temperature checks, to take COVID-19 tests, or to disclose evidence of their COVID-19 vaccination status, for example. We can help with all of that. Any kind of contentious issue in the workplace, we can help you manage those disciplinary processes, capability processes, and then again, any employment tribunal litigation, we've got very good experience at managing those on behalf of our clients. So thank you very much for attending today, and I will end the workshop here. Thank you very much for attending.